Title IX basically would allow biological males to compete in women's sports and things like that, but it also does more. It takes away your civil liberties. You could be removed from school just over an allegation of sexual assault or harassment. Joining us right now is Harriet Hageman. She's been a trial attorney for about 30 years. She is now senior litigation counsel. Harriet, welcome to the program. Thank you.
Thank you very much, Charlie, for having me. I appreciate the opportunity.
So if you are accused of sexual harassment or sexual assault on one of our campuses, that's it. Your career in academia is over, right?
Well, it can be, and that's one of the problems with how some of the folks in our education department and in the current administration define Title IX protections. Title IX doesn't mean that, but that is under the 2011 Obama Dear Colleague letter, and since then our schools and universities have been taking an approach to Title IX that has essentially stripped our students and our professors of due process rights and constitutional liberties.
So this is amazing, but let me ask you this. Why do colleges get to decide this?
Well, I'll tell you what Title IX is very, very simple, and it was adopted in 1972. It's a Civil Rights Act, and it says that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. In 2011, the Obama administration sent out what's called a Dear Colleague letter. It was a guidance document, right, and it essentially told all these universities that unless you basically strip many of these students or professors of their constitutional rights whenever there has been an allegation of sexual misconduct or as sexual assault, that they are not entitled to the general civil liberties and protections and rights that you and I enjoy under the 5th and 14th Amendment. So what it was the Department of Education that redefined what Title IX meant.
This is mind-blowing that they could take away your due process.
Absolutely. One of the things that they did is they lowered the burden of proof. So instead of it being clear and convincing evidence or beyond a reasonable doubt, as it would be in a criminal case if someone accused somebody else of sexual assault or rape, they lowered it to a preponderance of the evidence, which is basically a 51% standard. That was one of the things that they did. The other thing that they did is they stripped these students and professors, once they were accused of any kind of sexual misconduct, they stripped them of their right to confront their accuser. They would have hearings, and you might be accused of something and not even know what you've been accused of until you walk in for the hearing or shortly before that. They said that these students, and the majority of them have been men, the majority of them have been young men, they've basically said you are not entitled to cross-examine or even confront the person who's making this allegation, nor may you cross-examine that person's witnesses. So again, a fundamental due process right that we all enjoy pursuant to the 5th and 14th Amendment was stripped pursuant to this guidance document. Again, it isn't what Title IX says.
Right.
It's what that administration and the current administration want to interpret it to say.
So not only can you, and this also would allow biological males to compete in women's sports, right?
Well, that's the other aspect of this. Yeah. They read that statement cannot be discriminated on the basis of sex. They have read that to include homosexuality, gender identity, whatever it may be. And what they're doing is they're using that to argue that there cannot be single-sex locker rooms, for example. So if there's a young man in a high school who identifies as a female and he wants to play on the girls' softball team and use their shower, the way that this current administration and the Obama administration interpreted Title IX was that young man could shower and stay with. So if you've got overnight trips and you stay in a hotel, that young man, that young boy is entitled to sleep with the girls, regardless of how the girls may feel about this. So one of the things they're attempting to do is do away with single-sex facilities such as bathrooms, locker rooms, and hotel rooms when you're traveling for athletics or speech or whatever it may be.
Now, we're talking with Harriet Hageman, joined the NCLA as a senior litigation counsel. We remember the bathroom bill in North Carolina that really started all of this stuff. So if you're a college or a university, can a student take you to court if they feel like they've been wronged without due process?
If a student is wrongfully accused, or if they use what I refer to as a kangaroo court, let's say it's a sophomore in college and he has a relationship with a woman, and she comes in and says, well, he engaged in sexual misconduct, I'm going to bring a Title IX claim against him, and they pursue a Title IX claim. What we have seen is some success around the country where the courts have refused to allow the schools to strip these students of their due process rights. Probably one of the more famous one was out of the Seventh Circuit Court of Appeals. It was authored by our new Justice Amy Coney Barrett, and it was a case against a university where a young man had been stripped of his due process rights and his right to cross-examine and confront. And Judge Coney Barrett at the time ruled in the student's favor and said he's absolutely entitled to due process rights if you're going to attempt to kick him out of school or otherwise discipline him.
Absolutely unbelievable. Appreciate you being on the program. Very insightful. Thank you so much, Harriet Hageman. What do we do about this? Where do we go from here?
Well, we bring lawsuits, and that's one of the things. I'm with the New Civil Liberties Alliance out of Washington, D.C., and we have one case pending right now against Cornell. The oral argument is going to be in front of the appellate court, actually, day after tomorrow, and it is a case involving a professor that was wrongfully accused by a very vindictive student, and the school deprived him of his due process rights, again, refused to allow him to confront the accuser, refused to allow him to confront the witnesses, and did a variety of other things. And so, yes, he sued to try to get back his good reputation.
Unbelievable.
So
Harriet Hageman, thank you so much.
Those are the kinds of things we bring.
It's scary, and I appreciate the work you do. Thank you. Keep us informed. We'll talk again soon. We appreciate it.
Thank you, Charlie.
Yes, ma'am.